Welcome, everyone. It's been a while since we've done a Facebook Live. Hope everyone's had a great summer. We definitely enjoyed talking with many of you on the hotline. So just by way of introduction, my name is Craig Wagner. I'm General Counsel for the Utah Association of Realtors, and we have Lance Harrison, who's also Legal Counsel for the UAR. Thanks for joining us, Lance. Appreciate it.
Happy to be here.
So I wanted to talk with a couple of things today, and certainly if any of you have any questions, feel free to chime in and let us know. I wanted to first start with what the legal hotline is. And I know that's not a legal question or anything along those lines, but I wanted to first start with that because many of you may have not have called the hotline yet, or we just want to make sure that everyone has an idea of what exactly the hotline is. So the legal hotline is manned by myself and also Lance Harrison Monday, Wednesday, and Friday from 8:30 to 4. You can leave a message, frankly, anytime you want. But those are the days we generally return calls. We are not giving legal advice. We're just giving general legal information. Everything we talk about today is just going to be general legal information, and certainly you want to consult with your own personal attorney if you have specific legal needs. And we also encourage you to talk with your broker. And I know many of your brokers encourage you to call the hotline, and that's great. We hope that it is a great member benefit for all of our realtor members. But we do want you to have that communication with your broker as well to keep them in the loop. The hotline's been manned. I've been manning it for almost 10 years now, but it's been manned for, about 20 years. And so over the years, the UAR has answered hundreds of thousands of questions. And so we do hope that it is a benefit to you. Frankly, it's a benefit to us. We love talking with our members. We love knowing what's going on in the market. Many of the forms, the UAR Forms Committee drafts is a result of hotline calls. And frankly, many of the classes Lance and I teach stem from hotline questions, ways that we can maybe raise the level of professionalism and competency amongst our members. So it's reciprocal. We definitely want to thank you for your support of the legal hotline. And just this last month, we had a record-breaking, at least for the UAR, record-breaking day where we had 59 calls in one day. So hopefully not every day is like that, but it does show that it is widely used, and we hope that it is a great benefit to all of you. Anything else you would encourage our listeners and followers to take away from what the hotline is, Lance?
No, we really appreciate the people who call in. We love manning it. It's fun actually to talk to the members and get to know them and get to know the questions they have. For sure, just a couple things. We don't review documents, right? Sometimes people want to send us a contract or send us an email or, review this, tell us what we think. We're not your attorney, so we don't review documents. We talk about general situations and general information. But yeah, we love it.
Excellent. Well, I appreciate that. And like always, if you have any sort of questions, feel free to chime in with regards to the chat features. So we'll go ahead and we'll start with some of the topics we have, and then again, if you have any comments, feel free to chime in. Lance, maybe you had a couple of scenarios. Maybe walk through some of that, and we can talk these out. These are pretty recent things that we've discussed on the hotline.
Yeah, so we've had, it's been a busy summer for sure. We've taken a lot of calls, and it's been unique stuff coming up because of the market as it shifts. But one of the things that has been coming up a lot is talk about contingencies, right? So what is a contingency? What is it when you remove a contingency? So maybe we could start there saying, what is a contingency in a contract in general? I would define it as something pretty simple, as something that gives you an out in a contract, maybe something where, something has to happen and you have some options in that out of the contract to get out of the contract. And then there's usually some more to it. You get out with different conditions, like earnest money is released, or you get to keep it, different things with different conditions. Of course, you're familiar with these things. It's like the due diligence condition. You have some things you can do during that time frame, and you can cancel and you get your earnest money back usually. And once that's passed, you can't do those things. So that's what a condition is generally. Now we have the appraisal condition, we have the financing condition. You can also add your own condition, right? In a blank addendum if you want to add something else that you want to happen or to give you an additional right. The problem that comes up recently that I've seen a lot on the hotline is when someone removes a condition, right? And so we want to know, what are the risks of doing that? What does that actually mean? And what are some of the problems that we've seen stem from that? So just a good example of this is someone says, hey, due diligence, 8.1 in the REPC, there's a check mark. Is or is not conditioned upon due diligence? Is this contract, is this transaction, is or is not conditioned on due diligence? So by saying is not, you're removing basically that whole section from the REPC. And that's what the REPC says. It says, if you mark is, the following paragraphs apply. If you mark is not, they do not apply. So you're basically deleting that. So that's a really simple way to delete a really important part of the contract. And so the question that comes up recently with due diligence is, well, if I delete the section, do I still get the right to conduct tests, to do an inspection, to do other evaluations of the property? Because really maybe people want to say, I don't get the right to cancel based on these tests, but I still want to be able to do the tests, right? So people want a little bit more complex situation than what they actually do when they just mark is not. So that's something to think about. So if you mark is not and you actually want the right to do a test, you might want to add that in there and define what kind of condition you actually want instead of just deleting it wholesale.
Well, Lance, what if you do this, and we both have had these calls before. What if you remove the condition, so there's not a right to cancel. So under 8.1, you remove it. You say it is not conditioned upon due diligence. But then in section 24, you write in a deadline. So you write in a due diligence deadline, but it's not a condition of purchase. How would the two parties, the buyer and the seller, interpret no condition, but then having a deadline within the contract? Is that confusing, and how is it confusing?
Yeah, that is a great question, because I've had this come up several times, right? And we have these questions and it says, well, let's think about this. If there's no deadline or if there's no condition, but we also put a deadline, on its face, it does sound kind of confusing, right? It might be ambiguous at best, saying, hey, we don't know what this means, what this deadline means. Now we can probably guess maybe what their intent was. Their intent was either it was an accident, or their intent was, well, we still want some of the rights under 8.1 and we want until the deadline to do those. But they didn't say that, right? They just stuck a date in there without any kind of explanation or agreement about what that date means. So yeah, I think it's definitely going to cause problems. It's caused problems in the past. So I think you want to explain more clearly what you're doing if you don't want to just delete wholesale that condition.
Yeah, and to your point, Lance, I think it's best described when buyer and seller are negotiating to go under contract. It's in essence the honeymoon period, right? Buyer and seller are trying to find an agreeable solution to go under contract. And so if a buyer truly wants to still do an inspection on the property but doesn't want to make it a condition of purchase, it would be best to just spell that out, right? Then there's no ambiguity, there's no lack of clarity. It's clear to both parties, okay, this is exactly what I've agreed to. This is exactly what the sellers agreed to allow the buyer to do with regards to inspections of the property. Now, Lance, in the REPC, and I've got it pulled up for us. There are kind of the three big conditions of purchase. You have due diligence, you have appraisal, and you have financing. So 8.1, 8.2, 8.3 respectively. I'm hearing a lot of offers removing the appraisal condition, but still keeping a due diligence condition and keeping a financing condition. If I'm removing the appraisal condition and I'm reviewing that offer as a seller, what should I be mindful of as a seller that has an offer that does not have an appraisal condition but still has a due diligence and a financing condition?
Yeah, as a seller, I'm looking at a bunch of offers potentially, and I'm saying which one of these is the strongest? Which one of these is gonna most likely be successful, right? Or is gonna bind the seller the most, something like that. I'm trying to see which one do I want to choose. And if the appraisal condition is removed, right off the bat, you might think, oh, that's one less hoop we got to jump through, one less risk we got to take, that maybe if their appraisal doesn't come in. But in reality, when we look at what the appraisal condition does, there's a lot of overlap, right, with due diligence and with financing. So say, oh, you don't have the right to do an appraisal because you don't have a condition. Well, maybe you actually still have a right. You have a right to do any kind of evaluation you want during due diligence, right? You still have financing, and maybe in good faith, that includes an appraisal. There's a lot of arguments about why that still may be part of the contract. And then again, if you want to get out of the contract based on appraisal, yes, the appraisal condition is the simplest way to do that. But without it, you have many other outs, right? You still have financing if you're not happy with your terms. You still have due diligence. So you have a lot of overlap. So maybe it's not as strong as people think when they're removing something like that. There's just other things to look at for sure as when you're evaluating those contracts.
Yeah, definitely. You want to talk with your seller about the impetus between 8.1 and 8.2 and 8.3. But I would agree with you that under due diligence, if that's a condition of purchase, a buyer can do any tests, evaluations, and verifications of the property deemed necessary or appropriate by whom? By the buyer. So the buyer gets to choose, and the seller agrees to cooperate with buyer's due diligence. So if a buyer, even though it's not a condition of purchase, wants to do an appraisal, unless it's specifically excluded, where the seller says and buyer agrees that the buyer won't do an appraisal on the property, it does seem that the buyer would have a right to do so within the due diligence period. And certainly if the appraisal comes in low, what could a buyer end up canceling if the appraisal came in low in that instance? Even though there's not an appraisal condition, if the appraisal came in low and there's a due diligence condition, remember, buyer gets to cancel if they determine in their sole discretion that the results of their due diligence, however broad or narrow that is, they have a right to cancel. And so it certainly could be related to that low appraisal, even though they've waived the appraisal condition, because the due diligence condition is very broad. The other kind of aspect is the financing condition. You remove the appraisal condition, but someone keeps and says they need financing. Well, it probably means that they still need to get an appraisal done on the property, right? And if the appraisal comes in low, again, sole discretion, not satisfied with the terms and conditions of the loan, well, a low appraisal could have a direct impact on those terms and conditions. So again, I think most buyers agents and sellers agents understand this, but with some of the creative language and the creative offers that are out there, just be mindful of what these sections actually say and what is binding on both the buyer and the seller. Simply removing the appraisal condition does not alter 8.1. It does not alter 8.3. Lance, what's another topic? I'm looking to see if we have any questions. Oh, it looks like we do actually have a question from Chad. Thanks, Chad. So it says, are certificates of water shares part of the seller's disclosures in section 7 of the REPC? Okay, let's go ahead. Maybe what I'll do, let's see. I'll share my screen again. So Chad's referring to a seller's obligation to disclose, specifically water shares. And it does talk about in section 7I that the seller is to provide evidence of any water rights and or water shares referenced in section 1.4. 1.4, that is the reference where it's talking about water service and how the purchase price includes all water rights and water shares that are the legal source for seller's current culinary water service and irrigation. So the idea of certificates, we do have that as part of our seller's disclosure. So in the UAR seller's property condition disclosure, it does reference certificates, and that is going to be something that's going to be required if you are conveying a water share. Additionally, I can maybe give you a little insight. I know that the Division of Real Estate have been looking at water specifically in Utah, and as part of that task force, the UAR Forms Committee is looking at the water section specifically in the seller's property condition disclosure, and that is something that we're going to be discussing at our next forms meeting next week. So the seller's property condition disclosures may be changing a little bit when it comes to water, just to make it a little more informative to a potential buyer. Good question, Chad. Seeing if there's any other questions. I'm not seeing any. So Lance, what was another topic that you thought that we should maybe address today?
Yeah, so another issue that we've been seeing kind of related to those contingencies and creative things, or the honeymoon phase where you're negotiating. A lot of times in the honeymoon phase, you know, right up front, you're trying to get under contract, you're trying to beat out a bunch of other offers, and you have maybe a more complicated offer, right? You want a lease back, you want to stay in the property. You don't want to complicate your offer too much, but you got to get something in there. So maybe you have an understanding that there's going to be a lease back, or maybe you put your possession date out 30 or 60 days, but you want to keep it simple right now. So you don't do anything else. And you say, we'll negotiate that later, right? We'll get something signed later about that, but you do put in the contract 30, 60, something long-term about possession. Now, hopefully you're seeing some potential issues with that, right? Now, we want to keep the contract simple. Usually we want to get under contract, but we don't want to get under contract while we hurt our clients potentially in the future. So if we go under contract thinking we're going to do something in the future, I would slow down a little bit and start negotiating those terms now. If you want a specific price or rent, if you don't put that in right up front, it's actually not going to be easier later to negotiate that. And I would not assume that they're going to enter into some type of agreement for a certain amount or a certain deposit, something like that. So I see people say, oh, yep, we'll go under contract, long-term lease, but we'll just negotiate that later. I would slow down and get things in writing and do it the right way up front, even though it's going to be a little bit harder.
Yeah, I agree with you, Lance. And that's one of the reasons why the short-term leaseback agreement was changed to be an addendum, so that it makes it much easier as part of the initial negotiations to include that addendum, as opposed to trying to agree to the REPC and then also agree to this separate written agreement for a leaseback. And I get it. You're exactly right, Lance. It does make the contract a little more complicated, but it's worth it, right? That is part of the value proposition of using a realtor member, is that they have the tools, the resources, and the wherewithal to know how to help this transaction avoid some of the hiccups and the bumps. Because you're exactly right. If a buyer and seller go under contract, and in section 3.3, the possession section says, you know, possession is going to take place 30 days after recording, and then buyer, after going under contract, says, hey, seller, will you sign this lease addendum? There's not a whole lot of incentive for a seller to do so. They now have a legal right to stay in the property, and it does create some ambiguity there. So it's just trying to foresee, you know, any sort of issues or problems with that.
Yeah, and I've seen some creative language, right, saying, oh, upon closing we'll enter into a lease, something like that, and you think, oh, well, here we are, we're kind of agreeing, we're going to agree. But if you don't talk about terms, how are you going to agree on the terms of that lease if you just have that vague understanding you will agree in the future? It becomes kind of an issue when you talk about money later on, once you're already under contract.
Excellent. We do have another question. It looks like Brian. Brian has a question related to the FHA addendum. That is a Division of Real Estate form, and I'll pull that up. And when parties use language like a non-refundable upon acceptance, you know, earnest money, and how the two forms react with one another. And it's curious about maybe our opinion when it comes to that. So I'll pull up let me grab the form real quick. Let me see. And this is a common question. We are getting this question, and I'll be the first to admit that we are waiting for a potential test case of this. Not that we want any of you to be the test case. We certainly don't want you to, but there are a variety of interpretations to this. So first, let's say the FHA VA loan addendum comes after addendum number 1 that says earnest money is non-refundable. Well, I think in that instance, it seems to be pretty clear, because addendum number 1, earnest money is non-refundable. Addendum number 2, you have the FHA VA loan addendum. It does talk about how the buyer shall not be obligated to complete the purchase, and it says exactly what happens to the earnest money. And the reason why you go in the order or the chronology of the addenda is that every addendum has language similar to this that says, to the extent the terms of this addendum modify or conflict with any provisions of the REPC, including all prior addenda and counteroffers, these terms shall control. And then any other terms that aren't modified shall remain the same. Well, this seems, in their section 3, to amend it, right? To now make it refundable in this one particular instance, namely, if the purchase price is higher than the appraised value, or the appraised value comes in lower than the purchase price, right? So it's not tied to a deadline. There's no penalty of forfeiture. Where we then get the subsequent question is, well, what if you reverse the addenda, right? Let's say the FHA VA loan addendum is first, and then you have addendum number 2 that says earnest money is non-refundable upon acceptance. Well, it seems, Craig just told me that one addendum can modify a previous addendum. That addendum number 2 has very similar language at the bottom that says if there's a conflict, then these terms shall control. Wouldn't that be the case? And where it gets a little complicated with the FHA VA loan addendum is, if this was all that the 2 parties signed, then I would agree with that. That, yeah, you've now modified this addendum, and that last addendum is going to control. But what else is required for a loan to go FHA, Lance?
An appraisal.
An appraisal, and is the lender going to require the 2 parties to sign lender required documentation?
Yeah, they're going to have them sign the exact same language again, especially if you've modified the language, right?
Yeah, and here's the issue is that the lender, and this is in the FHA VA loan addendum, it says seller agrees to cooperate and sign any lender required documentation that does not substantially alter the rights and obligations of buyer and seller set forth in the REPC. So there's some rub there, but my understanding is that the lender is going to require the 2 parties, not just the buyer, but also the seller, to sign nearly this exact language, this amendatory language. And if the seller does sign that after going under contract, that seems to be the last thing that the 2 parties have signed. So there's an argument that the buyer can now make that the earnest money is still refundable in the event of a low appraisal. I don't know that. I'm just saying that these are some potential arguments a buyer could make if last minute they want to send over a notice of cancellation based on that lender required documentation that the seller has signed. But I'm waiting for a test case. I would imagine that this will be challenged, and I don't know who will ultimately prevail. But it is something the seller is going to have to overcome once they sign that lender required documentation. Does that make sense? Hopefully that makes sense. So any other thoughts? It looks like Brian had some additional thoughts. He said, I've seen a formal amendatory clause from a lender saying that the earnest money would be refundable. Exactly. I mean, that's kind of what we're talking about. It leads me to think that the earnest money refundability is driven by regulation and can't be contracted out. Sounds like you guys think the order of addenda can't control. I'm saying, Brian, that the order, the 2 things that the parties agreed to, that's going to control. But ultimately, the lender may require additional documentation to be signed. And the FHA VA loan addendum does allude to that in section 3 of the FHA VA loan addendum. And so for it to go FHA, that amendatory language is going to have to be agreed to by both buyer and seller. The question is, does the contract, namely the REPC, have language that requires the seller to sign that amendatory language, required by the lender, not just as part of the contract? So hopefully that helps. Any other thoughts, Lance, on that?
Yeah, I would just say a lot of this is educating your clients too, so they understand the risk, they understand what they're signing, they understand, you know, some of the potential outcomes, right? So nobody's surprised at the end of the day.
Right. Excellent. Are there any other thoughts about what we've covered so far? We've covered a lot of information. Any last topic, Lance, that you were thinking about?
The only one that's come up again recently that we've always kind of have discussions about is this idea of withdrawals of offers or counter offers. And so we can talk about that just for a second. And then if there's questions, we can answer those. But a withdrawal, this is kind of a unique one, right? This is usually before you're under contract. A buyer has submitted an offer or a seller has submitted a counter offer, and then they want to back out, right? They want to say, hey, let's take that off the table. And you can do that, right? And there's arguments about how to do it. I think there's a couple takeaways that I want to put out there. First of all, it's definitely safest to use the forms. I don't think anyone should argue about that. Get the form signed. There's a withdrawal of offer or counter offer form that's going to ask for the signature of your clients. It's going to be delivered, good notice. If you use that, you are never going to have a problem. The question comes up is it required? And there's different arguments about this, but I would argue that probably a clear communication of taking that offer off the table is probably good enough, but that doesn't mean you should just not use the form. I'm telling you, use the form, but that's a withdrawal doesn't necessarily need to be that form, in my opinion.
Yeah, and I've had this question as well, where someone says, well, Craig, in order to withdraw an offer or rescind or revoke an offer, don't I have to comply with Section 18 of the REPC that says it needs to be in writing, it needs to be signed, and it needs to be received? And I say no, because yes, that Section 18 is binding on the two parties once they go under contract. At this point, you're not. And so Section 18 isn't controlling when it comes to withdrawing or rescinding an offer. It's going to be part of the notice requirement once the two parties do go under contract.
Yeah, and along with that, it says notices required under the REPC. So you'd also have to make an argument, what are the notices required under the REPC? Is it spelled out in the REPC? Is it defined anywhere? Is it required? So yeah, a lot of good questions, and it can be confusing, and I get that.
Yeah, absolutely. Well, I appreciate it. Those that have been following with us, appreciate you tuning in and listening to Lance and I talk. We're definitely want to answer any questions you may have. We enjoy talking with you. I want to say that I love my job. I love answering questions. I've seen when I first started answering questions, I was dealing about third-party approval and short sales and how to navigate the short sell process. Now, not so much, right? I'm not answering any questions about short sell. I'm answering questions about multiple offers and creative language that agents have drafted on behalf of their clients. And so we want to be a resource and a benefit to you. So we appreciate all of your support and definitely want to be as helpful as possible. So thanks for tuning in. We hope to do this again shortly in the near future. So definitely feel free to let us know if you have any additional questions or topics you'd like us to cover.